Hi everyone, welcome back to my channel. My name is Bashini Veerasinghe. I am an estate planning and business law attorney here in San Diego, California. Today I'm going to be talking about why joint tenancy isn't an ideal way to dispose of property. But before I jump into our topic, I want to start off with a disclaimer as always. So just to get started, know that everything on this channel is for informational purposes only. It's to give you some background information so that when you're going about making decisions, you have some understanding and an idea of what you want to talk to a qualified attorney about. So this does not create any attorney-client privilege. It does not create a relationship between you and I, and it should not be treated as legal advice because depending on your particular circumstances, the advice can change. Also, please note that everything I talk about is specific to California law. So if you are located elsewhere, the information on this channel may not be applicable to where you are. You're going to want to consult with an attorney that is local to you so that you can get the advice that you need for your particular circumstances. With that said, let's dive in. So our topic today is why joint tenancy is not an ideal way to dispose of property. A couple of things up front. I'm going to be talking mainly about real property, meaning a home or land, even though joint tenancy is a potential way to hold other types of property as well. Joint tenancy refers to how title is held. And here in California, there's several different ways that title can be held. Two ways that I'm going to be comparing today is joint tenancy and tenants in common. I may make a separate video that goes into what these different types of titles are, but just to give you a very brief overview so you understand what we're talking about, joint tenancy and tenants in common type of titling comes into play when more than one owner is involved with ownership of property. So if more than one person, meaning you and a friend, you and your spouse, you and a sibling, you and a stranger want to purchase property together, how are you going to hold that title? There's two primary groups that title will fall into in these circumstances. One is joint tenancy and the other is tenants in common. Joint tenancy the primary way that they're going to be different when it comes to an estate planning point of view is that tenants in common gives each owner a present interest in the property, meaning they are a full owner when they sign the title or are placed on the title. But when they pass away, their share of the interest in that property can be given away to somebody else through estate planning, or if you fail to do estate planning through California law. The default law is called intestacy laws, and it basically says who's going to receive the property that you owned. Joint tenancy is different because joint tenancy, while it also gives you a present interest in the property to all of the people on the title, when one of those individuals pass away, their share of the interest automatically gets absorbed by the remaining individuals on that title. So an example of this would be, let's say you have A and B who buy a house together here in California, and they sign title as tenants in common, and B dies. B can give B's share of the property to B's child, C. Now A and C are tenants in common who owns that property. But if the property was held as joint tenants, A and B bought the exact same property in California as joint tenants, and B dies, that property now is 100% owned by A because B's share of the ownership got absorbed into A once B passed away. Now, the reason why we're talking about this from an estate planning perspective is that often we come across clients that want to bypass probate because in California, probate can be time consuming and very costly, and want to also bypass estate planning because they want to save the money or the effort of having to go through estate planning. So what they will often do is take property as joint tenants. So for example, A might be taking property knowing that A is going to leave that property to A's only child, B. And instead of creating an estate plan that's going to leave the property to B, what A does is put B on the title as joint tenants. And now A and B both own that property. And when A dies, B will own the entirety of the property. This is not ideal for a number of reasons. One is that you're giving present interest in the property to B, which means that if later you change your mind, you want to give that property to somebody else, or let's say you have multiple children and you only put one child on the joint tenancy title, you have now created a very big issue for yourself, because in order to change your mind, you need that person you added to title to agree with you to allow you to take them off of title. So for example, let's say you put your child, one of your kids, on title to your house, and later there's a fallout between you and your child. You cannot remove that child off of the title without that person agreeing that you could remove them. You may have to buy back that interest you gave them. You may have to wait for them to change their mind. There's all kinds of ways that creates a huge headache for yourself. And sometimes what we see in estate planning situations is where somebody did that, they put their child on their deed, and now a creditor of that child is coming after the property. This is also very problematic because you gave, whoever is on title has a present interest in that property, so their creditors can potentially come after that interest in order to collect their debt that's owed to them. So really, in the best thing for you as an individual is to keep the property under your own name and create an estate planning document that can help you dispose of that property after your death. That way you have full control of the property during your lifetime and protection from creditors of other individuals during your lifetime. And then you can decide whether to dispose of that property either through a will, a trust, or like a transfer on death deed. There's all kinds of different options that you can use, but the worst option for you to use would be joint tenancy in this scenario. And one of the other things we have seen in the practice of law is, and this is something I came across recently, where dad owned a house, had 3 kids, wanted to give the house to, at one point, wanted to give the house to his only daughter and put the daughter on title as a joint tenant. Then dad changed his mind, no longer wanted to give it only to the daughter, wanted to give it to all 3 kids. and asked the daughter to sign it back to him. Daughter did not agree, and then thought that they can create an estate planning document to go around what had been done in joint tenancy. So they created a will that said, I leave all of my property to my 3 children in equal shares. Dad then died, and one of the other kids came to a legal clinic and was asking for assistance and was wondering if they have any options for exercising their rights under the will. Well, the problem here is that joint tenancy property passes outside of a will. It passes outside of probate, and it's automatic. So as soon as dad died, the daughter's interest in that property vested. So she already had a present interest in half of the property as a co-owner. And now she has a present interest in the entire property, because when dad died, she absorbed his interest and nothing was left in his estate, because as soon as he dies, as part of the law, it automatically shifts to the remaining joint tenant. So here, the fact that he created an estate planning document that tried to undo what he did there does not solve the problem, because until the title is changed, it just does not undo that joint tenancy. So what the dad should have done is gotten the daughter to sign that interest back to him and put the property inside of a trust, so that he can later decide whether to give it only to one child, give it to all 3 kids, give it to charity, whatever dad wanted to do. So here was a perfect example that made me think I should make a YouTube video on this, because while in the short term, you might think joint tenancy sounds like a great option and an easy way to bypass probate and not think about estate planning, what you're really doing is giving up a lot of control. And not only are you giving up a lot of control, you are opening that asset up for potential issues with whoever you're putting on that title and their creditors. And here's a situation where dad may have wanted to sell the property later down the line, may have needed to sell the property in order to fund their retirement, or something of that nature. But again, dad would be blocked from doing such things, because unless the daughter agrees, the dad would not be able to dispose of that property during his lifetime or after his death without further instructions. So he would have needed to break the joint tenancy in order to do something in this regards. But simply creating a will at that point does not fix it. And here's a situation where he could have benefited from having sat down with an attorney and talking through the situation, either before he put his daughter on title or even after he put his daughter on title. There's potentially ways of breaking a joint tenancy, but he did not utilize those options, and just simply creating a document like a will does not undo the joint tenancy. You have to deal with the title issue that was at play. So with that said, I hope you learned something from this video. If you have any suggestions for future videos, please put it in a comment. Please note that the comments are public, so please don't disclose any confidential information on a comment. Thank you so much for joining me today. I look forward to seeing you in the next video.